Welcome to Empowering Plans, a show dedicated to identifying waste and undue expense in the health benefits industry, discovering ways to maximize benefits while minimizing costs, and empowering employers, administrators, and consultants to emphasize, once again, the benefit in benefit plan. Today's episode is brought to you by the FIA Group, empowering plans since 1999. Now here are your hosts, the FIA Group's own CEO, Adam Russo, and Senior Vice President and General Counsel, Ron Peck.
And Brady. Hello, everyone. Welcome to another episode of Empowering Plans, a special edition of Empowering Plans. I'm your co-host and a healthcare attorney here at the FIA Group, Brady Bizarro, and with me are some special people. One of them is Jen McCormick. She is our Vice President of General Consulting at the FIA Group. And say hello, Jen.
Good morning.
Wow, this is going well so far. And also, we have another special guest with us, Erin Hussey, another attorney in our consulting division. Say hello, Erin.
Hello, Erin.
Wow, I think Adam would be proud so far. We got a great crew here. Adam's off on some vacation somewhere enjoying the nice weather, but for some of us, the work has to go on. And we thought we'd jump on a podcast to talk about some exciting new issues happening in our industry, an important case about balance billing. So I think we should start with that first, unless anyone has any stories they want to tell about, their summer plans or vacations or anything like that now.
No, I don't really think that I have that exciting of a life to lead. So I wish that I had exciting things to talk about, but really balance billing and wellness plans are the highlight of my day. So
that's kind of what I thought, but I just wanted to make sure that was the case.
Yeah.
So we got wind of a case involving balance billing by a hospital that we think is interesting and we wanted to bring up and discuss. The case is called Centura Health Corp. Porter Care Adventist Health System, that's a mouthful, versus Deborah Agnew. So she is the patient in this case, and I'll give a quick background about what went on, and then I'll let the other people jump in and just give us some thoughts about what's going on here and what they think are the takeaways from this case. But what happened here was the patient underwent a surgery, and as everyone knows who's been to the doctors, and if you've had surgery, unfortunately, you know this as well, that you've got to sign a bunch of paperwork before you go into surgery. One of those documents is a patient hospital contract, which basically says that you, as a patient, agree to pay for any amounts that your health plan does not cover. Pretty standard stuff. We see it all the time. In this case, the surgery she had cost $21,000, according to the hospital's Chargemaster, which we'll talk about a bit later. And what was left over after her health plan paid their maximum allowable amount was $15,987. So who do you think got that bill? It was the patient, Miss Agnew. So she got a balance bill for $15,000, and that's obviously a big deal. She was very upset about that. So she got sued by the hospital for not paying this bill.
So balance billing is not a new concept, and having a hospital pursue a patient for unpaid bills isn't new. So why is this case any more special or different than the existing case law on the books?
That's a great question, Jen. So yeah, that's the issue here, right? Why is this a big deal? Why should we care about this? So what's interesting here is that the hospital in this case, so first of all, the defendants that they named in the suit, aside from the patient, which was the health plan, the TPA, everyone else involved under the sun, they all offered to pay the full claims amount to make this go away, right? They realized this was a case where the hospital wasn't willing to negotiate. They were just going to make this go away by paying the amount. The hospital said no. The hospital wanted here and still wants what's called a declaratory judgment from the court, basically saying a number of stipulations they want. They want the court to declare that this kind of a contract is in fact valid, that the charges here refer to the Chargemaster, not to some undefined, amorphous term, which is what, of course, the plaintiff was, Ms. Agnew was claiming. And basically, they want the court to acknowledge that all other identical contracts that this hospital may have with other patients are also valid and enforceable. So it's kind of a strategy thing here, right? For the hospital is saying, look, we want something to get on the record. We're tired of these health plans just paying the balance to avoid getting a decision. So it's smart on the hospital's part to press for this. And so that's what's different. That's what's new here. And
this also brings up a bigger issue of third-party agreements and contracts and how there's some confusion as how that relates to the SBD and how that can also have other effects on what's happening. So this is the patient-hospital contract, but then brings about the other issues of network contracts and how other third-party agreements can come into play.
Yeah, because this is not an in-network claim. There's no contract between the plan and between the hospital. So really, it's like the plan isn't really involved at all from the hospital's point of view. Of course, for the employee, they want their employer to defend them reasonably, and the employer's trying to do so. But this hospital is pretty gung-ho about, we want acknowledgement from the court that our contract's valid, that the amount due is in fact due. So there's going to be a separate battle here about what it's ultimately paid by the patient.
I think that the craziest thing about this case and what they're pursuing is not necessarily that they are looking for a declaratory action or judgment that whatever is in this contract is valid and binding, but the underlying issue of the amount of what was being charged and whether that was in fact a reasonable value for the services rendered. That's not even part of this. So to me, that's part that should be discussed, and I'm not sure if that's something that can be done. But if this case proceeds and there is actually this declaratory judgment, what's that going to mean for other cases?
Yeah, I don't know that it'll be that big a deal, frankly, if the hospital were to get a declaratory judgment on what they're seeking here, because really all that would really say is like, yes, these third-party contracts are in fact valid. And like Erin just said, like, we see these often, this is not new.
But wouldn't that be setting a precedent that's saying the amount or the value of reasonableness doesn't matter?
No, I don't think so, because that's not what they're asking for in declaratory judgment. They're just saying, like, is the contract valid, right, on its face? I think the contents of the contract or the amount at stake is going to be argued over separately, like we saw in the Glenn Dennis case, which was a Virginia case, which I knew I had to bring up. It's an important Virginia case where really that was the first RBP, reference-based pricing lawsuit that actually went to trial there, where initially the court there threw out the hospital's claim of breach of contract. In that case, the patient was facing an $84,000 balance bill, a lot more money at stake. And the court said, no, the contract that the patient signed with the hospital created undue duress on the patient. It was your money or your life, right? They threw it out. They said it wasn't allowed. And then, of course, it got overturned at the Virginia Supreme Court level and has now been remanded back to the circuit court in Virginia, and there's not been any action since. But there, the dispute is over the amount due, because the first court said, if there's any amount due here, it'd only be a fourth of what they're asking for. So there's still going to be a fight over whether the charges are reasonable. I think that's a different question than is the contract valid.
Well, even in the case here, it says that they have to relate to the Chargemaster amount, not to an open and undefined term. But isn't that the whole basis of a Chargemaster sometimes, is we're not exactly clear on the parameters there?
I would argue that is the case. And in taking both of these cases in combination, what does it mean for plans? So we're going to have to look to multiple different precedents and multiple different circuits and jurisdictions in order for us to determine whether or not we can decide if something is reasonable and whether or not we have to enforce those patient contracts that we have in place.
I think ultimately we'll have to wait, because we have pending cases in two different courts, and I think things are coming to a head, though, where you're going to see many more of these types of lawsuits, and plans that use some form of reference-based pricing will find that their employees will be in this problem, right? They'll be facing balance billing. They can't pay the bill, and they're going to be in court with a hospital. And so we don't yet have a ruling on the chargemaster or the charge amount, right? At this point, there's a lot of posturing by the parties. You're like, one side saying, at least make this contract valid, or agree with us that it's valid. That's a different question about the actual amounts. I think that fight is still coming later, and we don't have it yet. But we're getting closer every time one of these cases comes up.
So what you're saying is, at this point, we are just going to have to wait and see. But the good news is that people are actually starting to litigate and investigate the reasonableness of charges. So talking about waiting and seeing what's going to happen next, let's switch gears and talk about wellness plans.
So exciting.
So this has been a hot topic for a number of years. There have been a series of regulations, and actually there's a lot of interplay with varying regulations from ACA and HIPAA rules and ADA rules and GINA rules. It's very, very complicated. So Erin, why don't you tell us a little bit about what wellness plans are and why we're talking about this issue in the first place?
So wellness programs are offered with an employer-sponsored plan, and their purpose is to improve the health of employees and to reduce healthcare costs. So there's a lot that goes into wellness programs when it comes to the regulations. There's HIPAA, there's ADA, there's GINA, there's the ACA. HIPAA, which is not what we're going to mainly talk about here, but just a little overview, is the HIPAA rules provide two different types of wellness programs. There's participatory wellness programs and health contingent wellness programs. Participatory wellness programs are those that are not necessarily based on a health factor. There's no activity that you have to complete. There's no outcome-based health-related factor that you need to prove, whereas a health contingent program is the opposite of that. There's the activity-only health contingent program where you actually have to perform an activity, such as doing some sort of exercise program, or there's an outcome-based health contingent program where where the individual has to maintain a specific type of health standard. So that's HIPAA. So that HIPAA kind of just lays out the different types of wellness programs you can have. So under the ADA and GINA, there is a little bit more of regulations around the incentives. So the ADA generally restricts employers from making disability-related inquiries or requiring medical examinations. So the exception to that is if this is part of a wellness program that's voluntary, you can make those inquiries or require those medical examinations. And under GINA, it's the same thing, except that GINA prohibits employers from requesting employee genetic information. So the exception to that, again, is as long as this is related to a wellness program that's voluntary, you can ask that information.
Yeah, so this is a big deal. There's a lot of regulations here. And the reason that people care about this is because wellness matters, right? You want to have, if you are a self-funded plan in particular, it's important for you to have a healthy risk pool or a set of employees who otherwise care about their lifestyle and do what they can to maintain healthy behaviors. So under the current rules, there are these incentives or a stick that employers can put into place to encourage or incentivize employees to take advantage of these plans.
Hey, Jen, isn't the incentive the carrot? I thought the stick was the...
There's both.
Oh, okay.
So
all right.
both.
So make sure you had that right.
Brady's hungry.
Yeah, it is lunchtime, so...
Yeah.
Sorry, go ahead.
So under these, there's two different ways, right? So you can penalize somebody or you can incentivize somebody, a carrot or a stick.
There we
both,
go.
Okay?
There we go.
So there was a particular case, I believe, right, that came about. These rules went into effect for ADA and the GINA rules in 2015, I believe, and then subsequent to that, there was a case that was filed, AARP versus EEOC, I think, right?
Yes.
And that case was discussing some voluntariness, right? And that's pretty relevant to where we are now. Can you tell us a little bit about that case?
Yeah, so back in 2016, the AARP sued the EEOC, claiming that EEOC's wellness incentive rules that apply to wellness programs were coercive and not truly voluntary. So what that means is that an incentive can, as carrot and stick, it can be a reward. It can be a reward or a penalty. So if you're offering a wellness program that's supposed to be voluntary, but you're also penalizing employees that can sometimes be up to $1,000, it doesn't really seem like that's a voluntary program. So that was questioned in that case, is if you're having these penalties or incentives, are they truly voluntary? And the court disagreed with the EEOC's, lack of definition of voluntary. They didn't even define it. And so what happened is that they ordered the EEOC to rewrite these wellness program rules specific to the incentives.
So in March of 2018, they said, you are directed to rewrite these wellness rules so that we can have a better understanding of what is and is not permissible. It's the end of July 2018. We don't have any rules. What does that mean?
Shocking.
Yeah, so they ordered them to in January, but in March they were supposed to at least give a little bit of guidance of, okay, we are going to rewrite rules. That's our goal. Or we're not going to rewrite rules. They're going to be vacated. But they didn't really give us any guidance at all. So that kind of leads to the political climate right now and why that is. So right now there is still an opening in the EEOC, the chair, and they're waiting for the Senate to submit nominations for the chair, which hasn't happened yet. So that's kind of where it's been thought why they haven't taken any action and why they haven't given employers any guidance.
You know, I can say as the resident political expert, that was a good
this is for Brady.
summary of the political climate. I think that was very good. But we're also going to ask you, like I often get asked, to give a prediction. What do you think is going to happen? If you had to guess, feet to the fire, what will we see or not see?
All right. Don't hold me to it. But here's my prediction.
It's on tape. It's,
So the EEOC initially asked for a 2021 deadline, and the court did not give them that. They gave them a 2019 deadline. So my prediction is that they're not going to rewrite new rules by when they're supposed to submit the proposed regulations, which are in August, and that is obviously a month from now. So I do not expect that they're going to be able to come up with even proposed regulations by August, and especially the political climate, all of that. So that is my prediction.
So just kind of taking, there's two questions. The first question is, what's going to happen if these rules are vacated?
So if these rules are vacated, you go back to the pre-rule guidance, it kind of leaves employers a little bit blind, like, what do we do? Obviously, the 30% incentive by that point is going to be vacated. So anything over that obviously wouldn't seem like employers would be able to do that. But anything under that is kind of where it's a little bit of a gray area. So, which I'm sure everyone loves to hear when it's a gray area.
So the issue is whether or not 30% is voluntary. So if the rules that say that 30% still makes it voluntary are vacated, then you could argue that if there's nothing that sets that ceiling, that maybe I could use 40%. But what you're saying is if they don't think 30% is voluntary, then why would 40% be voluntary?
Yeah, there wouldn't be an argument.
What makes 25 different than 30 versus 35? So second question.
Those are numbers you can understand, Jen.
I know, right? That's the kind of math I can do. What do we do now? I have a wellness program in my plan. What do I need to do? How do I need to get ready for 2019? What do I need to consider?
So employers just unfortunately have to consider some options here. They're going to have to see, is there any way we can offer this wellness program without an incentive? Obviously, that's not going to be ideal for employers who want to incentivize their employees to go on their wellness programs. But another option also is there any way to offer this wellness program without having any disability inquiries, without requiring them to have a medical examination, or without requesting any genetic information? Is there any way any of the ADA or GINA regulations can be avoided? Can you offer the wellness program without that? And considering those options, I would say you'd be in line with the rules being vacated.
That would require substantial changes to your existing wellness program, though, if you were removing all of those qualifications. No HRAs, no biometric screenings. So,
not ideal.
Yeah, that's certainly not an ideal situation. So the moral of the story for both the balance billing cases and the wellness programs is to sit tight.
Sit tight.
Sit tight and tune in next time because we could go on for hours about this stuff, but unfortunately we actually have some real work to do, which we'll get to. But listen, everyone, thanks for joining us. Tune in to our webinar on August 14th. Looking forward to that. On behalf of myself, Jen McCormick, and Erin Hussey, thanks for joining. And, of course, Pat. I almost forgot Pat. Adam would have killed us. Pat, our amazing producer. Thank you all for empowering your plans with the FIA Group, for listening to our podcast, and we'll see you next time.
Thank you.
Thank you.